Right, it's 11 o'clock. Good morning, everybody, and a very, very warm welcome to our Women in Sectional Title webinar. I was really pleased to see that we had a record of attendees of just under 200 registering for this webinar today. So I guess that everybody really wants to know what's going on and wants to be at the forefront of all these changes, as this Women in Sectional Title is always there to just assist all of us to get together, to share, to learn, and to grow. And I think it's such an important place to be. It's a safe space, and more I'm receiving so many emails from women in our industry who are asking for help, who are looking at becoming more educated, and who are showing an interest in our industry. I would like to mention, before I thank our sponsors, I'd also like to mention the two Michaels, Michael Schaefer from Zedfin and Michael Addison from Adsure, who have also managed to sponsor us. We've had two interns who've joined us here at Women in Sectional Title. The one has already completed a 6-month internship and has been taken up in the conveyancing department of a law firm. So we're very proud of that. And I think as players in this industry, we need to be bringing people, especially women, into our industry. And sometimes it seems so difficult. It seems like such a big job and a big thing, and there's so many hoops to jump through. But I would urge you all to just sit down and think, how do we get people into the industry, even if it's 1 or 2 or 5 or 50? I think we can all play a role. So even if our sponsors are listening and they're wanting to get more involved with bringing women in as interns to different areas and rotating them, please do consider sending us an email. Of course, we wouldn't be able to do what we're doing and to become more successful without our kind sponsors. So thank you very much to Zedfin, to CIA, Meeting Pal, We Connect You, Sectional Title Solutions, and PKF Octagon. And also, please don't hesitate to go to our videos page and to see some interviews with all our various sponsors. It's very important to us, and we don't associate with people that we don't believe in. So thank you again. We have full confidence in our sponsors, and we'd really like to thank them for taking up another year with all of us. Yeah, so if you can host an intern, please email me. I would really greatly appreciate it. Okay, on to today. So I'm exceptionally excited to be able to sit with you. Think of it as sitting with a familiar old friend, well, maybe not so much of the old, hopefully, but a familiar face who really wants to get you all involved in the changes that have been spoken about at CSOS level on the ground. So I did have, again, the privilege of sitting with the CSOS legal department over the last 2-3 weeks, to be working through the legislation. And it's not only the Sectional Title Schemes Management Act, but it's also the regulations, it's the management rules, and it's the Community Schemes Ombud Service Act as well, to see what the rationale is for making all these changes going forward, because we do need more changes. We haven't had a lot of amendments since the acts became effective. So I think it's about time that this happened. Please bear in mind, and I'm going to reiterate it a few times today, what we're going to discuss here today is not new law yet. These are proposed changes that the legal department has put together. The changes still have to go through great processes. So it's got to go through NAMA. They've got to be open for comment to associations like ARC, who deal with homeowners associations, with land reform tribunals. The PPRA still has to have an input. And most importantly, of course, the Department of Human Settlements needs to look at all these amendments. So this is really just a teaser. And I've been asked specifically by the Community Schemes Ombud Service not to share a presentation with anybody for fear that certain of these amendments might still change. So we're looking at what's going to happen, and I think it's important for you. Mostly we've got managing agents on this forum to be ahead of the game and to know exactly what is planned for the future. So grab a pen, grab your notebook, This is like a little, as I said, tutorial where you're going to just be taking notes. At the end, I'll also be telling you that if you do want the bills and the government gazettes where everything is set out, you need to email me at marina@bbmlaw.co.za, and we'll gladly send you this information. Okay, so let's start, and lots to discuss, lots to go through. I'm going to give you an opportunity at the end if you'd like to ask some questions, and we're also going to be taking copies of the chat today. So if you've got things to add, you're worried, or you really feel strongly about something that must be added to all this legislation, please do not hesitate to send me information and questions. Okay. All right, we'll start with the Sectional Title Schemes Management Act. And actually, there are very few changes to the Act, but the one is great. I really like it. So let's start. Just this is the first one, which doesn't really add anything, but they've added the definition of a unit. So they're saying that a unit means a section with its undivided share in the common property, apportioned to that section in accordance with the quota of the section. So a unit hasn't really been properly defined. We've always said a unit equals a section plus the undivided share in the common property. So here we've just got it nicely neatened up. The excellent news now is on extensions. So you know that extensions fall under Section 24 of the Sectional Titles Act as amended. And extensions have been causing a lot of problems for not only bodies corporate, but also for the banks during transfer processes, and also for trustees who are trying to see whether or not that extension is legal or illegal. We've got many complexes around South Africa where people have just gone and done what they want. So they've been like cowboys, they've extended their sections. Sorry, let me just start my video again. My video went off. There we go. So they've basically ridden roughshod over the sentiments of trustees in the complex and done what they've liked to do. And probably about, 18, 19 years ago, I remember the Pietermaritzburg Deeds Office getting very upset about illegal extensions and trying to stop the transfers in complexes where there were illegal extensions. And I still think that they need to do more in that regard to get involved. But what this change is, it says, it's about money. It's about the money people have to pay when they've extended their section. Because sometimes you extend your section, but you don't get that land surveyor in, you don't get the conveyancer involved to redraft so that that section is incorporated into the PQ. So listen to what this new section is going, this proposed section is going to say. Where occupation has taken place of the extension, in other words, you're living in it, you're living in the lounge that you've extended, and the extension has not been registered within 90 days, the body corporate must charge a contribution as if it was registered. So that's very good news for bodies corporates, because obviously then their levy contribution will go up. You can't extend your section and expect to live in it without paying anything extra on your levies and then selling it at a higher price. Not so. Listen to this though, it goes on to say, this proposed section says, if 90 days passes and the owner has not further extended proof of appointment of a land surveyor and conveyancing attorney, then the trustees must appoint the relevant professional to register the extension at the owner's cost. Fantastic. I love that, because at the end of the day, so many people don't. They get their special resolution to extend the boundary or floor area of the unit, and they think, oh, lovely, we've got the body corporate consent. That's fantastic. But then they don't go and regularize it. So this is proposing a lovely regularization of the extension, and the body corporate, the trustees, need to then become more involved in that. So hopefully they do. Then just the last one in the Sectional Titles Act, the last change in the Act, talks about the administrator. And we know that an administrator used to be appointed by the High Court. So that's your next heading, administration. Used to be appointed by the High Court, Then that was amended, if you'll remember, and it went into the realms of the magistrates court. So when we were talking to the legal advisors now, they were talking about, what's set out in the new proposed legislation is that the Ombud's office deals with administrators. So in a similar way to having a panel for executive managing agents, they would also have a panel for administrators. So our view, the people who were assisting with this, I'm not of the view that the Ombud should be taking this on. We personally think that there should be an option to go to the High Court. I'm not enjoying the Magistrates Court on these administration applications at all. And I think more work needs to be done to train administrators and to have those administrators in a list for the High Court, because this is something that changes status. So we didn't think that the Ombud should be dealing with that. So that was the input from our side. So let's see what they eventually do on that. It will be interesting to see. Okay, now I'm going on to the regulations of the Sectional Title Schemes Management Act, and the regulations on that act. It's important because regulations are really the implementers, the way that you're implementing parts of the act. So the new thing to note there, your first heading under regulations, now this is regulations, is the addition in the definition of the accounting officer. Accounting officer. Remember, the accounting officer quite recently was taken out of the act, and we said everybody had to go to auditors. Now, accounting officer has been added in the definition, and it's as per the definition in the Closed Corporations Act. And I'll tell you more about the accounting officer and what they can do just now. We're also now talking about the Advisory Council. Next heading, Advisory Council will be taken out of the Sectional Title Schemes Management Act. You can understand there was an Advisory Council facilitation mechanism, but they didn't even really use it, and nobody was appointed to an Advisory Council. So they're taking that out of the Sectional Title Schemes Management Act, and you'll see that it'll pop up later in the Community Schemes Ombud Service Act. So Advisory Council's finished. What will interest you is the minimum, next heading, minimum amounts for the reserve fund. Okay, so we know that the reserve fund, we've always known that if you look at your reserve fund at the end of the previous financial year, and there's less than 25% at the end of that previous financial year, then you can add on 15% of the budgeted contribution for the incoming year or for the next year. And then it talks about between 25% and 100%, if that was what was left in the reserve fund of the income of the body corporate, then it just said, well, basically, you must just make sure that you've got enough for maintenance. The proposed amendment on this actually says add 10% of the total budgeted contribution for the next year. So it's 15%, 10%, and then if you've got 100% of what you should have in your reserve fund, then obviously you don't need to add anything. So it's 15%, now it would be 10% with the changes. Okay, so that's something. But here's the thing about the reserve fund in the regulations. We're still in the regulations. The developer now, they want the developer to establish the maintenance, repair and replacement plan. So we do have a couple of things with the developer, new requirements for them to adhere to, and that developer on new developments must establish the reserve fund before the inaugural meeting, before the first general meeting. Like that, I really do like that. I think we needed an ombuds for developers because the number of developments that we're dealing with at the moment, where they're major dramas, is really, it's disheartening, actually. And it seems to me like developers do get away with a lot. And of course, at the current moment, we can't take developers to the ombud. So that's something I did mention actually in my liaisons with the legal team. Guys, I do agree with the scrapping of registered post. Yeah, I do agree with the scrapping of registered posts. By the way, they've been in the chats. It's an archaic system, and unfortunately in South Africa, it really doesn't work. So that's a great suggestion. Thank you. Marianne says, as long as there are teeth to take the developers on. Well, I think you'll be happy to know that wherever there's contraventions of these acts, there will be teeth, and we'll talk about that towards the end. Okay, your next heading under regulations is the curator ad litem. So, it's like a vague clause. This has always been in the background, and I haven't had many dealings with this, I have to say. So when an owner decides that they want to take the body corporate to task because the body corporate is not following up on owners who are contravening the act, or there's a damages claim, for example, against somebody else that the body corporate hasn't taken up, an owner in the current legislation is allowed to go to try and appoint a curator ad litem, which is a court appointee, to take the body corporate on or to take a third party on for damages. So now in the new proposal, the chief ombud is going to appoint a specialist expert. So you're not going to have to go to a curator ad litem at the High Court. And I think that might be a good thing. Obviously, it's all subject to resources and to whether or not the ombud going to have those resources. One thing I can tell you all is that I was very impressed with the legal team at the Community Schemes Ombud Service. Really, as we were going through these, the understanding of what needs to happen in our industries there, and I was chuffed. Okay, now we're going on to the management rules. So we've done the Act, we've gone through the regulations. Now I'm taking you through the management rules. Okay, so the management rules, let's look at, firstly, again, in the management rules, they've added the accounting officer under definitions, and they've managed to fix up that whole situation about how many trustees you have in a sectional title scheme. So a lot of people said, well, if you've got 4 units, it's a problem, because the current legislation talks about if they're less than 4 units, then everybody is a trustee. If they're less than 4 units, if they're more than 4 units, then it's as per the Sectional Titles Act and rules. But if you have 4, it was silent on 4. So they've amended that just to fix that up. So it says now, if there are 4 or more trustees, then you have to just appoint trustees in the normal course. So that's nice, good. Okay, everybody's going to be excited about this because this provision used to be in the old management rules, and it was whipped out quite unceremoniously, I have to say. And it's a requirement for office of a trustee, the requirements for the office of a trustee. And now it goes on, you can't be an unrehabilitated insolvent, you can't be of unsound mind, you can't have been convicted of theft or anything to do with a disingenuous crime, conviction in that fraud or anything like that. But what do we all want? We all want the situation where if a trustee is in arrears, they're not allowed to be a trustee. Not so. So it's back. It said a trustee who is in arrears should not be allowed to hold office. The current legislation tried to say that unless there's a judgment or an award of some sort against you, then you're not allowed to be a trustee. But it's come back to say you're in arrears, and also no person may be nominated if they're in arrears. Not the law yet, but it's going to come. And I think, you're probably looking at the management rules being changed in only a couple of months' time. It's not there yet. I think you can still be a bit vulnerable in terms of these clauses, because if I say you're in arrears, maybe I don't like you, maybe as a managing agent, I haven't done my homework, maybe I haven't picked up a payment that you've made. So I would be quite circumspect in implementing this and just be sure of your facts. Because I know at all the meetings before meetings, everybody's running around to see if anybody's in arrears, to see if they can vote and do all those kind of things. So yeah, it is, Susan. It's a bad idea if levy statements are inaccurate And yeah, disputed charges, I definitely wouldn't be going and taking somebody out or not allowing them to be nominated if there is some dispute on record, because then you can start getting yourself into some serious trouble there. Maslene says she agrees with the trustee requirements. And Marianne says, does that mean you cannot be elected, or that you cannot be elected? And if you are a trustee, you cease to hold office as soon as you are in arrears? Well, we've asked for clarity on that, because I think I think you would be able to take somebody to the CSOS to say, you are a trustee, you were elected when you were in good standing, but now you're not in good standing. And it says here, it basically says that you are not allowed, a trustee who is in arrears should not be allowed to hold office. So if you go to the CSOS and you can say in all clarity that they're in arrears, that person is in arrears, then he or she should cease to hold office immediately. And I think you'd be fine with that. Okay, so Caroline says trustees should be required to qualify with relevant examinations to ensure that they are fully knowledgeable about their duties and sign a declaration of acceptance of duties, and need to be competent and skilled. That is something else that the Ombud is going to be working on. I can't say too much about that yet, but if you run into arrears briefly, also a good question, actually. I suppose depends how badly everyone wants to get rid of you. Yeah, not too sure about that, but as long as you can prove that that the person is in arrears at the time, then they shouldn't be able to act as a trustee. Marion says exams are not practical, wouldn't get any trustees that way. Well, Marion, I can tell you that in international jurisdictions like Israel and the UK as well, but they are leasehold, you have to be educated. You have to do a program within 60 days of becoming a trustee. And if you don't pass those, or if you don't even write them, then you're out automatically. So I think it's something we need to aspire to. When will the public participation process for these amendments begin? That's Teresa. Hi, Teresa. So ultimately, they're looking at, well, I think it's a bit optimistic, but they're trying to start talking to stakeholders by the end of April. Again, I think it's optimistic because we've got a lot of holidays in April. So yeah, I would say May, June, July, those would be the months for public participation on this. I hope that helps. Yeah, utility sections. Yeah, I think Shannon, the definition of the unit would need to be clarified with regard to utility sections and how they would affect CSOS contributions. I can tell you, by the way, with CSOS contributions, they're looking at taking away the tiers and just making it 20 Rand across the board. 20 Rand across the board, whether you live in Steyn City or whether you live in Vosloorus. So that's basically what I can tell you. Whether it comes about, I'm not sure, but that is what they're talking about. All right, something interesting for you, and also for the people who are wanting to be executive managing agents, is that wherever reference is made to managing agents, they add the word or executive managing agents. So there's a lot of political will, literally political will, behind executive managing agents at this stage, and it's something to consider. There's an interesting topic about the indemnity of the executive managing agents now, which I'll come to as well. Okay, so we're moving on now. We're still in management rules, and your next heading is inaugural meeting. Your first general meeting with the developer. And there are two additional items on this agenda. The first one is a motion proposing that the auditor to be appointed holds office until the next AGM. So it's not just an appointment of an auditor. It's a specific motion of a year that auditor needs to be in, which is good. The current legislation, all it talks about is that the auditor can review evidence and can do certain things, but this is setting the auditor in stone, literally the contract. as long as it obviously gets ratified. And then a motion for the approval of the maintenance, repair and replacement plan by the members in a general meeting. That never happened in the inaugural meeting. So it's happening now in the inaugural meeting. So I think it's just, everybody's trying to make that inaugural meeting start on the right footing. Developer open account, reserve fund, etc. Next heading, annual general meeting. On the agenda, there are a couple of new things on the agenda, which again, go more to being proactive. So an addition is to approve the agenda on condition that no new business not already on the agenda can be added. So you're not allowed to add anything onto that agenda during the course of that meeting. Okay, then the second thing is that at the annual general meeting, there's a provision now that you must receive reports, not only of the 10-year plan, but of the implementation of the 10-year plan. Implementation of the 10-year plan. They need a report, and they want to report on amendments in the last financial year to the rules. That's an addition. They want to report on common property maintenance, which must be on the agenda, and a report on security issues. Interesting. That's a new one. You have to now advise on the interest to be charged on arrear levies in that AGM. So it's not just a trustee resolution at the end of that meeting. That must be dealt with in the meeting. And also a report on other directions or restrictions. So I'll just go through those again. Receive reports on implementation of the 10-year plan. Report on amendments to the rules. Report on common property maintenance and security issues, as well as the interest to be charged on arrear levies, and any report on directions and restrictions. Okay. Marion, I see you talking about the quorum. So there was a clause regarding the quorums, but that didn't make any degree of sense to any of us, and so they're going back to work on that. And I think that's something that is quite important to look at. I do have some change on the quorums, some advice on the quorums here. You know, when you get this, there's going to be no change on proxies, by the way, as well. That's not going to be changed. You're still going to be only able to hold 2. But the change that comes in, when you have your meeting postponed because you don't have a quorum, you have that meeting postponed to a week, same time and the same place. It's not going to be a week. It's going to be 72 hours, not 1 week. 3 days. I think it helps. And any reference to the National Credit Act will be changed and amended to the National Treasury. And that's something that's just sort of aligns with other acts. In your management rules, under the next heading is reserve fund. You must pay. So the law as it stands says that what monies can you pay out of your reserve fund? So reserve fund would be for emergencies. Maintenance and replacement, to fund the maintenance, repair and replacement fund, not so. But also, if there's a court order or an adjudication order, you have to pay out of your reserve fund. If there's an order, but it left out an award by the Ombud himself or herself. So that's been added. Now we go back to accounting officer, and what it basically says is that where there 9 or less, so less than 10 units, your accounting officer is back on board and can be appointed to independently review and audit, sign financial statements. I'm not sure how you guys feel about that, but I think it's better. Don't know how managing agents feel about that. On to further information about the executive managing agent. So under management rules, there's a new indemnity for executive managing agents. So at the very beginning, when we used to give all our lectures about executive managing agents and the fact that they now their liability, because they come on board, they're working together with the trustees, but at the end of the day, they take on liability. Well, listen to what this indemnity says. It says, An executive managing agent shall be indemnified by the body corporate against all losses, expenses, and claims which they may incur or become liable for in their duties, unless they're mala fide, which basically means dishonest, negligent, whether they act negligently or omit something negligently. So that's quite something. I know one of the legal advisors to the Ombud wasn't really happy with this indemnity, quite like holding managing agents responsible for everything. So look, I don't think you're going to get too many executive managing agents unless you have this kind of indemnity, which to me makes sense. Yeah. Yeah, that does the 72 hours mean exactly the same as the week? It's automatically postponed to 72 hours? Yes, it does. It's automatically postponed. Okay, Susan says at present, what qualifications must an executive managing agent have? Same qualifications as a usual managing agent, but because they used to take on that liability, then they could charge more. So then the question is, if you're not taking on such a great degree of liability, but yeah, I mean, I still think you need to be charging a higher fee as an executive managing agent. And again, you need to realize also the Ombud is pushing for executive managing agents. So it might be better to get on board with executive managing agents. Okay. Right, so now we go on to the Community Scheme Ombud Service Act, and the most of the changes are actually here. Let's go through them. I've told you that it's 20 Rand across, it's going to be 20 Rand across the board. Something that I raised, which I'm not happy about, is the situation. I feel that homeowners associations are almost like got 1 foot in the Ombud service and 1 foot out, because it's not compulsory for a homeowners association to get a compliance certificate through the CSOS. At this stage. And I think when we chatted about it, I think they realized that actually they do need to bring the homeowners associations more into line with the community, with like the sectional titles kind of situation. Because if you're wanting to place all these penalties on them and bring them into this act, and their definition is a homeowners association of a community scheme, then why are you not reviewing their compliance documentation? So that's something hopefully they'll consider. So the CSOS Act, what the bill, the CSOS Act, the new bill now says, is that this community scheme ombud has to provide for, and the wording is compulsory registration of community schemes. Compulsory registration of community schemes. So it really makes it clear that you've got to register. To promote transformation and sustainability of the community schemes, obviously and correctly so, I think you need to look at the transformation, and there's a transformation fund that's also coming in. Hi, Michael. Michael Schaefer says we get plenty of queries from homeowners associations for the appointment of an executive managing agent, which isn't immediately possible given applicable legislation. It would be good if CSOS applied their minds here, if they are if they are wanting that. Okay, thank you. Also, we're looking at something new here with CSOS, the appointment of a deputy chief ombud. I think the chief ombud has a lot of different various functions which they want to promote and they want to push a little bit harder. The addition to definitions, there's going to be an administrative penalty. So now there'll be a penalty imposed by CSOS on people contravening the Act, and that money then will go to the Community Scheme Ombud Service. There will also be a Community Scheme Ombud Service Advisory Council. Somebody says, can auditors submit a compilation engagement report? I think it must be a full audit. I might be wrong. Maybe we need one of the auditors. Somebody from PKF can answer that. Yeah, thanks, Alistair. Oh, nice to have you on board, Alistair. It's a full audit. Yeah. Okay. Now, also something I don't like is a con adjudication. What they want to put in something called conciliation adjudication. So that when you go to CSOS, you sit there and you go through a conciliation. And if you don't find resolution in that conciliation, then you just move on to adjudication. So the same guy who's mediating, or woman, goes on to adjudication. And there we said, we don't like that because it's where you're wearing two different hats. So they're going to look at that. The rationale behind that is, most people don't really reach agreement at the conciliation. You can immediately move on to the adjudication. And I think they should rather say to people, do you think you can reach agreement? I know when my clients are never going to reach agreement. A mediation is a complete waste of time, and they should just move on to adjudication quickly. Okay, so we've got the purpose of the Act. Managing agents, your ears need to be burning here, because it says one of the purposes of this Act now, they're going to add, is to provide for the regulation of the conduct of managing agents. So we'll see, watch that space, and that should be coming into the regulations, which we don't yet have, of the CSOS Act. Something that's quite intriguing here is that a board member of the CSOS cannot be a Minister of Parliament, a Member of Cabinet, Deputy Minister, a Premier, Member of the Provincial House of Traditional Leaders, or Member of a Municipal Council. So that's quite interesting. Caroline, oh no, it wasn't Caroline, Teresa, how will applicants to CSOS Advisory Council be chosen? The only stakeholders not represented are owners. How do owners get their voices heard if CSOS is taking over the Advisory Council? I think there will be an opportunity for owners to be on that council, Teresa, for sure. Okay, so also you can't be on the board if you're not a South African citizen. Something I've handed over to our conveyancers here at BBM Attorneys is about the developers. So the developers, it says, now this is we're talking about the CSOS Act. The developer shall, within 30 days of opening the sectional title register the community scheme. They want more registrations. It's no doubt. They haven't captured enough of all those schemes. Something else I'm going to hand over to our conveyancing department. Obligations on financial institutions, and this is fabulous. It says no bank can lend money unless the scheme is registered. No bank can lend money unless the scheme is registered. So that's going to be a change to the Act. And no bank is able to give a bond, no mortgage bond on any scheme, where it's they're not registered. And this is great because this is almost pushing consumers through another angle. And that's what I would have done in the first place, actually, because you would have gained traction in a very big way there. We're going to have the appointment of inspectors. So this is coming into the CSOS Act, suitably qualified, that you can appoint the ombud or an adjudicator. An adjudicator can appoint an inspector, and the inspector has to give 10 days notice to come to look at a scheme. They need to have an ID card. They can enter exclusive use areas or common property areas, and they must have access to all records, books of account and record, but they're not allowed to seize or attach or take anything away unless they've got a warrant. So then they talk about offences. If your body corporate doesn't register, if you fail to register, if you fail to comply with an order, or you fail to comply with an inspector, and all these offences, that you can get a fine, or you can go to jail for 5 years, and if there's a second offence, then you can go for 10 years, together with a fine. Again, I don't get the impression that CSOS is going to put anyone in jail, quite frankly. But it's there anyway. Where an inspector indicates a contravention, the Ombud Service can instruct a person to comply with the Act. So the Ombud can go directly from an inspector. You don't have to go through a CSOS hearing. If an inspector goes out and they see something wrong, the Ombud can immediately instruct somebody to comply with the Act within a reasonable time or pay a fine to the Ombud Service. So the Ombud Service is looking to increase the capacity for receiving fines. You can't, obviously, there's a new provision about prohibited conduct. You can't discriminate against schemes or service providers based on the Constitution. You can't, Marianne says, is this due process? I assume you're talking about offences. Yes, because it's statutory. It's through your statute, so it is due process. Record keeping, you must retain for 5 years anything that to do with the CSOS. That's what's been added there. Now, I just want to quickly go through with you because we're running out of time. You know, under Section 39, Section 39 are all the sections upon which you can take something or dispute to CSOS. So we know Section 39 talks about you can go to the CSOS if there are financial issues, compliance issues, etc. A lot of people that you know have been kicked out of CSOS because they didn't comply with Section 39. So in the new bill, it's Section 51, but we had a nice argument with the legislators there to say, listen, just keep it as Section 39. People know that it's Section 39. And what is here, they've added, on financial issues, you can apply to the CSOS to get an order for payment of outstanding levies to CSOS. So if I'm an owner and I see that my body corporate hasn't been paying the levy for CSOS, I can go to get an order that the body corporate does pay to CSOS. There was something on loss of rental income. So this is what they put in on financial issues. They said you can get an order for loss of rental income. And we pointed out to them that that's not possible because you've got the rental tribunal dealing with that. That would be exceeding the jurisdiction. Also, you can now go, not now, in future, you can go and get an order requiring the building to take out insurance. Lovely one, like that. Scheme governance documentation is an order, and this is new, requiring any person in possession of any accounting or other document to return this community scheme documents, and that applies very much to managing agents. And then the last one talks about the powers of the adjudicator. And the adjudicator says may invite any persons or witnesses to an adjudication hearing. And we said, I specifically was really vociferous on this one. I said the adjudicator should be able to subpoena, never mind invite. Nobody's going to come to a hearing if they're invited. You should be able to subpoena anybody that has an interest or that needs to be speaking at an adjudication hearing. And they took that quite well, and that might be changed. And the powers of the adjudicator can also, another thing is, a new thing is to rectify non-material errors on the award. And that we've seen, we get an award, we say, this is nonsense, doesn't make sense, can go back and they can change, but it's not on facts or law, it's just on errors that he's made in his award. The last two things that I can tell you is that in the CSOS Act, there's an amendment to say that if the CSOS Act is in contravention with any other legislation, the CSOS, with regard to dispute resolution, the CSOS Act will take precedence over that, which is something that gives a lot of gravitas to the CSOS Act. There was also discussion on other bodies that could come into the CSOS under definitions. So, you know, we've got body corporates, homeowners associations, sectional title or retirement villages, share block cooperatives. There was something that they were discussing on social housing and bringing a lot of social housing developments under the CSOS Act. And we've said, look, my view is very much get this impeccable, get this working to full capacity, take another 10 years if you have to, and then look at other things. But I don't think that's going to be an absolute disaster because there's just not enough capacity for that. So that brings us to the end, and right on time to the end of our webinar. Obviously, if you'd like to email me again, or wherever this is, I found this in the regulations and through government gazettes and under the bills. Please with pleasure, I'll send it to you. Again, this is all not law yet. So don't go telling everybody, you know, it's 20 Rand across the board or whatever. We know that it's coming through. I think the acts are definitely going to take longer than the management rules and regulations, although I'm assuming or suspecting that they might want to package everything together. But I just want to say thank you so much. It was great to see some really familiar names on the attendee list here. It's fantastic. We can post a recording of this webinar. Thank you, Teresa, to the Sectional Title Living Facebook group, and thank you for always putting on such interesting information onto that group as well. It's an opportunity for us to work together, and what's exciting for me is we can shape the industry together instead of just getting ambushed with things that don't make sense to us working on the ground. So thank you. In April, we're going to be talking about tenant disputes and evictions of tenants. Also a hot topic. So thank you. Hopefully you join us for that as well. Take care. And I appreciate all of you. Thank you. Thank you. Bye-bye now.